Hey, everybody, this is Rob. I just wanted to reach back out to you regarding the research I've been doing on Arizona law, specifically in Maricopa County. I recently did a video on the Ninth District Court of Appeals on September 5th, 2024, with their decision on no longer posting booking shots or mug shots online prior to any convictions. Continuing with my research, today I'm going to go over the Maricopa County criminal process. It's more detailed, it covers more steps, and with recent events, I wanted to give you the outline of what's going on with some detail. And hopefully, there'll be good information for you to see. My previous video for the mugshots decision from the Ninth District Court of Appeals is available on my channel, so please feel free to go search for that. It was just posted last week. But let me go ahead and share with you the screen from the website from Maricopa County on criminal process. And I will put the link in the description for everyone. Here in Maricopa County, the criminal process is anything to say to the police, family members, or to others can be used against you in court. So keep that in mind. That's part of the Miranda rights. One of the rights that you get read if you are pulled over by the police or investigated or whatever, if you ever have your Miranda rights read. Therefore, do not discuss your case with anyone except your attorney or someone from our offices. So this is good information. It is from the public defender's office regarding the criminal process, as you can see on the page. And it also states, remember that you and your attorney are partners for the best possible result for you. If you would like the attorney to discuss your case with family members, you must give the attorney permission. You and your attorney have different responsibilities during the proceedings. So as the client, you always decide whether or not to go to trial or take a plea agreement. Now, with current events, this is something that you've been hearing about here in Arizona, especially Maricopa County. So these are some of the options that are available, decisions that the client gets to make, whether or not to testify. They also have the decision on whether or not to appeal after being convicted and whether or not to file a post-conviction relief, which is acronym PCR. Unlike an appeal, the client is responsible for obtaining and filing a PCR paperwork in a timely fashion. Your lawyer is responsible for making strategic decisions such as motions to file, object in court, witnesses to call, and issues to raise on appeal and PCR filings. So keep in mind, your partnership with your lawyer and yourself is important. You need to respect that lawyer, especially a public defender who's there to look out for your best interests. Work together as a team. Because again, even though you're the one on trial, your lawyer is there to work with you and for you. Some of the steps going forward in a court appearances is the first one, important information about your court appearance. You must appear in court for all court hearings unless told otherwise by your lawyer. It can take several months for a case to move through the court system. As we've learned on recent court cases, it does take several months. And I've done some recent videos on our Maricopa County Attorney Rachel Mitchell, showing how some cases have been from a few years ago, even as far back as 10 years ago, that were being investigated by her investigation team and her staff. It does take time to go through paperwork and documentation and witnesses and gathering information and speaking with people to build a strong enough case to go to the prosecutor. And Rachel Mitchell has done a wonderful job, as I've said many times before in my previous videos. And in this case, this is one of the reasons why. You can help your lawyer being on time to court, come to court prepared with any questions you have for your attorney, and wear appropriate clothing. These are to me, some common sense points, and hopefully everyone else can see that for themselves. Watching this video may help you just so that you have a reference point to be able to prepare. And going forward with this, we have the initial hearing and appearance, which I will click here. If it clicks, okay. The initial appearance is your first step in the criminal justice system. At this appearance, you will be informed of your charges, appointed an attorney if you are unable to afford and retain the services of a private attorney. In a lot of cases that we see, there are people that are indigent and or unable to afford a private attorney. So they do let the judge know that they do need a public defender, I should say, and they would be assigned one. Unless they want to represent themselves. We've also seen cases in recent years where there have been those people that want to represent themselves. You also are advised of your next court date and court location. You're also given release conditions or a bond, if applicable. So again, in recent events, you've got cases that may or may not apply, receiving a bond, depending on what charges are being brought against you, your financial situation, the means you may have. I know I've seen it in movies, a plethora of TV shows. So be aware in that initial hearing and appearance, which is very important. These are the things that are covered in there, as well as you get to sit with your lawyer and discuss them if necessary prior to the initial hearing and appearance. Moving on to arraignment. Arraignments are heard in the Superior Court. At the arraignment, the court will enter a not guilty plea on your behalf and will ensure that you have an attorney representing you on your case. Signing representation. If the court determines that you cannot afford to hire an attorney, one will be appointed to assist you, and you will receive instruction on how to contact your assigned attorney. Pretty much like the initial hearing and appearance, but the next step would be once you let the courts know that you need a public defender, or if you do hire an attorney, this is the kind of thing that the assigned representative would address with you. Assigning a judge and next court date. The court will also assign your case to a judge and set your upcoming court dates. The next court date is an initial pretrial conference hearing. Now, the explosive case that we talked about last week, everything's already been set. They've already prepared. They've already assigned. There was enough information with the felonies that were given to a specific person here in Arizona. And if you go to the docket, which is available on the court's website, you would see that they already have the steps already dated. Now, that doesn't mean they can't change if the lawyers or the judge or for whatever reason the client have valid reasons to update those and get approval from the judge. But just so you know that in the case that the explosive case from last week, they've already been assigned. And going right to arraignment is probably going to be the first step. Moving on to felony indictments. If you receive an indictment or a felony offense, you will not have a preliminary hearing. Once again, the case from last week that hit the news did jump to this because there were felony offenses. You will not have a preliminary hearing. Instead, the grand jury has already found probable cause to charge you. Your next court date will be for arraignment. So it is quite interesting in some cases that you would not go through the first few steps. The grand jury, when a grand jury is involved, their decision stands because they found probable cause and are able to allow for you to already be charged, and you need to attend the arraignment. No skipping it. Make sure you attend. And hopefully you have representation. If not, you should have representation from the get-go, just so that the ball keeps rolling forward. A preliminary hearing is the next step. Many cases in Maricopa County are a set of preliminary hearings. A preliminary hearing is a hearing before a court commissioner at which the state must present evidence, usually a police officer or police report, that a crime was committed and that there is probable cause to believe the defendant committed the crime. The accused will be assigned an attorney, if the person does not have an attorney to assist them at the hearing. Then you have the case step disposition or dismissal or proceeding. If the commissioner finds that there is not sufficient evidence to believe that the crime occurred or to demonstrate, that you probably were the person who committed the crime, the case will be dismissed. If the commissioner is convinced that there is sufficient evidence to believe those 2 points, your case will be set for initial pretrial conference, IPTC. Again, the case from last week that hit the news, you'll see that that's already been taken care of. There's already dates and times already listed on the docket. Next is the scratched or vacated preliminary hearings. And this quote states, occasionally preliminary hearings are scratched or vacated. This may mean that the formal charges were not filed or that the prosecutor has chosen to take the case to the grand jury. The case last week went to the grand jury. The charges may be refiled. Be sure to provide any address changes to the post office so mail from the court about your charges will reach you. If you do not, you may not receive notice of a court hearing. If you do not appear for the court hearing, a warrant will be issued for your arrest. You don't want that to happen. So either a good home address or a P.O. box, something along those lines, you want to make sure you keep the courts up to date. And there's plenty of ways to keep them up to date. And simplest way is a phone call or go to the courthouse. And we have several here in Maricopa County, so be aware. Next step would be waiving the hearing and plea agreements. You may waive the preliminary hearing if you wish. Your attorney and the prosecutor reach a plea agreement. Typically, prosecutors offer plea agreements that provide a better sentence that you would obtain if you chose to go to trial and lose. If you choose to go to trial and lose. If you accept the prosecutor's offer or give up your right to a preliminary hearing, a trial, and an appeal, you will enter the plea agreement in court that same day. Your sentencing date will be scheduled approximately 1 month from the date upon which you enter into the plea agreement. So plea agreements can happen from the get-go, if you will, preliminary hearings and a trial or even an appeal. So you want to be aware of that, but also be aware of the constitutional rights that you'll be giving up, okay? Moving on to plea agreements, here are some consequences that you should be aware of. If you do plead guilty, you give up several rights, like I said just a moment ago, including the right to trial. It is important to review the entire plea agreement with your attorney and that you understand the consequences of entering into the agreement before you sign it and before you enter it in court. If you have questions about the plea agreement, be sure to discuss them with your attorney. I would think you'd want to do that prior to going to court. So it's very important that you read that verbatim so that you are fully aware of what the plea agreement contains, because as we've seen on many court shows, the document itself, the courts only read what's between the four corners. Everything that's in there is included, and that's all they capture or work with. Even though you sign a plea agreement with the prosecutor, the judge is not required to accept the term of the agreement. That's an interesting fact, because you may go ahead and have a plea agreement set up with the prosecutor, but the judge who has reviewed or will review or already has reviewed all of the information, grand jury, what was provided to the prosecutor, also from others, the individual who's on trial and their lawyer's information, the judge may decline it. So be aware of that also. Now, if you reach a stage of trial, a felony trials, I should say, are heard by a jury unless you, your attorney, and the prosecutor agree to have your case presented to a judge. Jury trials are people like you and I, citizens of the state, and we all have the duty as citizens to be called to jury duty. I have been called to jury duty in the past. It's a process, which is a process in itself. I may go over that in a future stream just so people are aware what it's like here in Arizona, which is probably a good one so that you're aware. It's not something to take lightly, and it's not something that you should always be afraid of or try to get out of. It's our responsibility as citizens to serve on a jury if at all possible, barring any incidences that prevent you from doing so. Pretty straightforward, these these explanations. So I'm glad that it's very straightforward for everybody to understand. Um, in sentencing, so let's say you do get convicted and you had sentencing, your attorney will have the opportunity to speak on your behalf. You also will have the chance to speak to the judge, as we've seen a lot of that in court cases on television or in TV shows or in real life if you attend court cases. If you want anyone else to speak on your behalf at sentencing, you can let your attorney know in advance of the hearing. This way, they can set up times, dates, having those folks available and ready and waiting in the wings so that that doesn't hold off the court case and they can time everything appropriately. Those who cannot attend the sentencing can also submit a letter on their behalf, on your behalf. So that's interesting also. You don't have to actually physically attend. You can actually write a letter, get it to the attorney, and the attorney can have it read into or provided to the judge so that it's part of the court records. The letters may be addressed as to the sentencing judge, but should be sent to your attorney so the attorney can review them and submit them to the court on your behalf. I keep saying things before I get to the section, but it's because I'm excited. This is neat. Okay. For the appeal process, a little bit more detail. If you are convicted after a trial and you want to appeal your case, you have a right to an appeal and right to file a petition for post-conviction relief. If you entered into a plea agreement, you may have waived your right to an appeal, but you may still file a petition for post-conviction relief. After sentencing, you have a very limited time to file a notice of appeal or post-conviction relief. I believe they vary from state to state, so be aware in your state. Discuss this with your attorney prior to sentencing. If you wish to appeal, your attorney will file a notice of appeal or notice of post-conviction relief on your behalf. An appeal is a request to a higher court to review your case because Superior Court made errors regarding law during your trial. An appellate court will not reweigh their evidence. The court will review the trial transcripts and the briefs submitted by the parties to determine if Superior Court made any errors and if those errors actually impacted the outcome of the case. So, as we saw in last week's case that came to fruition, or indictments were sent out with multiple felonies, prior to that, the lawyer involved did submit an appeal and raised it up to the Superior Court, and it came back again. Nothing was found to be detrimental to the decision that was made at the initial court. So, I mean, there's options for your lawyer to work with you as long as you work with them. Being honest and truthful throughout the process is most important. Sharing all the information, and be forthcoming with the lawyers, prosecutors during the depositions, things like that, is most important to your advantage and everyone else's involved. We really want to make sure that the court system that's laid out is followed to the law, and those that deserve to be brought to trial and either found innocent or guilty are treated fairly, and no constitutional rights are stepped on. And I believe that we're going to see many more cases. There's some in the news currently that are rather interesting to many folks to be involved in and watch online. But in general, I wanted to make sure that everybody knew in Maricopa County what's involved and make sure that you were aware. So now I'm going to end with my exit exit. Where am I at? My exit, if I can find it. Um, there we go. There we go. My outro, we call it. And I want to thank you all for attending the my video today. And I'll make a note to go through the jury selection process. I think that would be quite interesting for folks. And we'll see what happens from this day forward on my future streams. And I am still continuing my Rachel Mitchell County, Maricopa County's attorney successes in 2025. I'm doing it in parts because it's a lot to pull together. There's been quite a bit going on. Okay, thanks for attending. Have a great day. And don't forget, if you like what I provide through all of my videos and shorts, do subscribe, view, and I appreciate any time you have to watch my videos. Thanks.